Welcome to another episode of Unraveling Intellectual Property with Michael Stein. Today, we're going to be talking about U.S. provisional patent applications versus U.S. non-provisional, or also known as utility applications. And we have as our guest, Marc Whipple, an attorney here at Stein IP. Marc, please tell us a little bit about yourself.
Hi there. I have been practicing for about 25 years. I was the general counsel of two different intellectual property heavy companies, Meyer Glass Design, a design studio, and Incredible Technologies, a game and arcade game designer. Then I went into private practice where I've been very happy. I am a licensed patent attorney as well as being licensed to practice law in the state of Illinois. I usually do technology related things, but my background is in general science, so I do everything from chemistry to electronics to computer programming.
All right, thank you for that, Marc. So let's get started with a U.S. provisional application. Why don't you tell us what a U.S. provisional application is and what is the purpose of the same?
Sure, a provisional patent application, and by the way, you'll hear us say provisional patent, even lawyers, even though there really is no such thing. It's only a provisional patent application, and you'll understand why soon, is a way to essentially stop the clock in the patent office. In most patent offices, if you disclose your invention to the public, you will have a very hard time getting a patent, or in fact, you may not be able to get one at all. It depends. So what you want to do is ideally file a utility application. But if you aren't sure that that's really economical or you aren't ready to do that, you can file what's called a provisional patent application. Once that's in the patent office, you have 1 year to file a full application based on it. If you do, the date that it was filed counts as the date of your utility application. So you have a year that you can disclose it, you can shop for investors, you can do preliminary marketing investigation, all kinds of good things.
So basically, it's like a timestamp for your invention. Uh,
Yes,
that's correct. And then it also gives you priority to your U.S. application, and it also prevents prior art from from other countries being used against you,
correct.
or actually uh, prevent you from being prevented from filing in other countries.
Exactly. It counts both for your disclosures and everyone else's. Normally, if someone else discloses before you file your application, again, you'll have a hard time, if at all, being able to get a patent. But this stops the clock for everybody for a year. It's incredibly valuable.
And I mean, I think you mentioned a brief couple things, but what's the benefits of a provisional application? Cheaper, easier, or what?
It's much easier. There's a lot fewer required things that you have to file with it. You don't have to file any claims. Most good patent attorneys will draft at least one catch-all claim, but you don't have to file the claims, which are the big expensive part many times of a full patent application. The drawings can be much simpler. The specification can be simpler. In a real rush, you can really just pile a lot of stuff in there and see what you can do. But you do want a patent attorney to go over it. Some people will just take basically their invention file or their notebook page and send it to the patent office, and that's not necessarily the best idea. But it is much cheaper. It's much faster. The filing fee is much lower. It's just generally a really efficient way to get that time and let you do more investigation into the economics of your invention.
Right, but not really more time to develop the application, right? Because you need to have basically all the information, all the disclosure in the provisional if you want to get priority to whatever you disclose and support for your claims in your utility application, correct?
Correct. If you come up with new features for your invention, you'll need either a new application or you'll have to file them separately. There are different ways you can approach that, but yes, it does stop the clock on you as well. So if you add stuff, you have to deal with that separately, which is not a problem, but it does need to be dealt with.
And then we get to the utility application or the non-provisional, which commonly called, I guess, somewhat interchangeable. What is I mean, what's the benefit of a non-provisional application, and why do you need to file one? And how does that differ from the provisional application?
Well, that's a matter of style sometimes for attorneys. When I do provisional applications, mine are usually pretty close to full utilities as far as the specification goes. And the nice part about that is that when you're ready to file, the specification usually takes the longest to complete and it's already done. So if you are in a time rush at the end of your year, it does save a lot of time and it does mean that you pay a little bit less on the back end. But once you file that non-provisional application, it becomes a regular patent application, what people think of as a patent application. You can then proceed with it to get a utility patent, which then is used to prevent other people from practicing your invention in the country or countries where you have filed them. By the way, a U.S. provisional patent can be used to claim priority in some kinds of international filings as well. So it does have even that benefit. Again, it depends. But it's always a good idea. There are other ways to approach it. If you think you're going to be doing business all over the world, you should definitely bring that up with your patent attorney as fast as you can. But once you've got the patent, you usually license it to a big manufacturer or you practice it yourself if you are a company of a size and capability to do that. And if somebody else tries to sell the same thing in the market, you can tell them no, you can sue them, you can get damages. It's very, very useful.
And so what happens with the provisional? Does it kind of just go away, or?
At the end of the year, the provisional application essentially goes away. The provisional application, other than to make sure it's technically complete, is never reviewed by the patent office at all. You can think of it as them sticking it in a drawer for a year. And if any time during that year you come with a real application and say, I want to claim the benefit of my provisional, then they will get it out and review it and make sure that the two intermesh correctly.
And so if we go to international filing, does the clock start from the filing date of the provisional or from the non-provisional? So let's say you want to file a Paris Convention or you want to file a PCT application.
Typically, the filing would start from the date of the provisional application, which can be both good and bad. It means that certain things happen a year earlier than they might otherwise happen, which might not necessarily be ideal. But on the other hand, it does give you that year against prior disclosure, both from you and from many other inventors. So net, it is still a very good thing.
And I guess since the provisional isn't published until the non-provisional, it's possible to just simply, if you're past that 1 year date, to not claim priority to the provisional application?
It absolutely is. And in fact, very rarely you will see people say, for whatever reason, I don't want to file a patent application. I'd rather practice this as a trade secret for as long as I can. And the nice part is the provisional never gets published, so it doesn't disclose your trade secrets.
Okay, so the provisional is basically a timestamp. It's a marker. It gives you priority date. It's less expensive to prepare generally because you don't need the claims or even an abstract. I understand you said that you try to get it as close as possible. But the big caveat is you have to include all of the information in the provisional to get the full priority for the non-provisional. Have I
Exactly.
Yeah.
And that means that if you do come up with new things, trivia point, one utility application can claim priority to multiple provisional applications, which means if you do come up with something new, say 2 months later, we can file that. And how that works is a little complex. I won't go into it, but it still is very useful and certainly can be a really good idea to do.
Okay. Is there anything else you'd like to add? Or I think we've covered quite a bit in this episode.
Yes, I am a huge fan of these. They actually, to show my age, became part of the law right as I began practicing law. A lot of attorneys who are older than I am don't like them because, that's how attorneys are. But I've always been a big fan. They've saved my clients a lot of money, a lot of time, and I recommend them highly in most contexts.
All right, Mark, thank you for your time and expertise. And to all our viewers out there, thank you for watching another episode of Unraveling Intellectual Property with Michael Stein. See you next time.
Thanks, everybody.
All right, so long.